Good afternoon, Your Honor.
Good afternoon. I think we're still waiting on the state. I don't see Mr. Hernandez or Mr. Hartwell, but
And I just sent you a message. Would you look at it?
okay. Is Mr. Day there? Carl Day?
No.
So I wonder if Ms. Evans filed a motion to substitute counsel for Mr. Day.
And so she filed a motion. I mean, she filed a letter of rep.
Yeah, please. This possesses. Yeah. Is that word even exists?
She filed a letter of rep, but this is an old case, like 2013, I believe.
So was Carl Day, well, this is a CR 20 case, Tiffany Rankin. But was Carl Day the underlying attorney by chance?
No.
He had filed on the motion to revoke?
Well, he filed his letter of rep after the motion to revoke. I mean, it just had that case number. It didn't say motion to revoke. But he filed it after the motion to revoke.
Man.
We got 2 letters of rep and neither attorney. I wonder if Miss Evans knows about, well, we're gonna need to talk to Miss Rankin to figure out who her lawyer is, because she's got 2 that are saying that they are lawyers and neither one of them are appearing, so.
Now, Miss Evans filed a motion for continuance this morning with her letter of rep due to a death.
Yeah, let's see, I didn't see the continuance.
Or that's what Ms. Parker told me.
Yeah.
See appearance of counsel and then. Yeah, that could be an e-file. The only thing that's in the clerk's system is appearance of counsel, so. Still, we're probably going to talk to Ms. Rankin and find out who she intends on representing her, because I'm confused right now, so. Who are we ready on?
Well, we're not. We're waiting on the translator for Mr. Adams and Mr. Wood, and then Mr. Waldron was not aware of his case. We were fixing to reset it, but then he was told otherwise.
Okay, so Mr. Manning got anybody that's ready? Or Mr. Schmidt?
No. Mr. Schmidt's going over plea papers. Gonna be just a minute.
What about Miss Warrington? Is she in there? Because I've got Mr. Weiner. He's ready. He's in.
Okay, we'll get her. You know.
All right. Well, let me know, and then as soon as you bring her in, let me know, and I'll call Mr. Weiner in.
Your Honor.
All right, Miss Warrington, let me get Mr. Weiner brought in, and then we'll begin your hearing.
Yes, sir.
All right, good afternoon, Mr. Weiner.
Hey, Judge.
All right, this is State of Texas versus Cynthia Joyce Warrington, CR 24-38, set for pretrial today. Any announcements from the state or the defense?
Yes, Your Honor. And uh, so state was recently, it was pointed out to us, there were some factual inconsistencies between a search warrant and the report. And I believe Mr. Waldron, who is representing Mr. Edwards, the co-defendant in this case, has more of those details. After discussing, Mr. Waldron pointed those out to us. After discussing it, we believe that this could result in the suppression of the search warrant, and because of that, state is moving to dismiss Ms. Warrington's case because we believe the evidence obtained subsequent to that search warrant would be suppressed.
Okay. Anything to add, Mr. Weiner?
That's my understanding, Judge.
Okay. All right. So you're making an oral motion to dismiss right now?
Yes, Your Honor.
All right, then, based on the state's oral motion to dismiss this case, the court grants the same, asks the state to file a motion, and the court will sign an order dismissing Ms. Warrington's case. Does she have any other holds here in Van Zandt County that either of you gentlemen are aware of
I don't believe she has any other holds, Judge.
at all? Any other counties?
No, Cynthia, do you have any other holds from any other counties? I don't believe so, Judge.
Okay. All right, then, court will sign an order dismissing the case and send it to the sheriff's office so Ms. Warrington can be released.
Thank you very much, Judge.
Thank you, Mr. Weiner.
That's all I have. May I be excused?
Yes, sir. Good to see you.
All right, see you.
Do you want to go ahead and do Mr. Waldron?
Yes, that's fine. This is cause number CR 24-39, State of Texas versus Ronald Jack Edwards. All right, same announcement, Mr. Hartwell.
It is, Your Honor, but if I could beg Mr. Waldron to kind of fill in the record, just so that there is a record. I know he found most of these inconsistencies, so if he would indulge me in just kind of filling out the record for me.
Judge, Mr. Edwards has a companion case in Smith County. In obtaining the discovery in the Smith County case, there were things I believe even that I obtained that Van Zandt County had not been made privy to in regards to offense reports surrounding the investigation that originated in Smith County with this tag unit. Upon reviewing all the records from the Smith County case and the offense reports, the contents of the offense reports did not match the contents of the search warrant affidavits that were submitted to this court. I did a comparison, ginned up a motion, and outlined exactly where I felt like there were factual inaccuracies in the search warrant compared to what the officer's own offense report showed. And based on those inconsistencies, that's where we've ended up today with the state moving to dismiss out of concerns, and rightfully so. And I appreciate the state being straightforward. And on top of this, recognizing that there are problems with the search warrant in this search and arrest warrant in this case.
All right, and was it a search warrant that was issued by this court?
It was, Judge.
And would you mind relaying that warrant number so that I can review that?
Judge, I don't have it in front of me, but I will get it for the court for review. The affiant was Ryan Haley with DPS tag unit, and I could find that fairly quick, but I'll make sure before I leave here the staff has that warrant number. Okay.
So, Mr. Hartwell, my understanding is that state is making an oral motion to dismiss Mr. Edwards' case.
Yes, sir.
All right. The court finding that the state has made a motion to dismiss this case, the court hereby dismisses cause number CR 2439. And does Mr. Edwards have a hold?
He does. In regards to the Smith County case, obviously this suppression issue will be carried over to Smith County at some point, would be my guess.
All right. Thank you, Ms. Walter. All right, okay.
Thank you, Judge.
As soon as the docket's over, I'll try to get orders, just generic orders dismissing the case signed and sent over to the jail.
Thank you, Judge.
You're welcome. Thank you, Mr. Waldron. Good to see you.
Thank you.
Do we have anyone else that's ready or do they need time?
Mr. Manning has some issues with paperwork and Mr. Schmidt is still working.
Okay,
When you say the interpreter, if you'll let me know.
okay. And Miss Rankin's not in the courtroom, correct?
Now we can get her.
No, that's okay. We'll wait. Let's see. All right, as soon as I see the interpreter, I will let you know. What about Mr. Platten? Is Mr. Vergara in there?
No, not yet.
Okay, do we know in that email transcript you had this morning, if he was asking to reset this case this afternoon also? Mr. Platten?
I'm not
Your Honor, Mr. Vergara was not initially mentioned. However, Mr. Platten's office did reach out this morning and asked for the same February 18th date for Mr. Vergara, because Mr. Platten, I guess, is still stuck in the sentencing in that Smith County case.
Okay, well, just do me a favor. Next time they reach out to talk to you, have them loop Patty in as the coordinator so that she can get this information to me so that I'm not having you play middleman, so that we're aware of what's going on. They should know to do that.
Yes, sir.
But always tell them that they need to go through the court.
Yes, sir.
All right, court will reset Mr. Vergara's case. What date did we give him earlier? Do you remember, Mr. Hartwell?
I believe it was February 18th.
All right, court will reset cause number CR 2440, State versus Humberto Vergara to pretrial on February 18th. If you'll just let Mr. Vergara know that his attorney was present today and the case has been reset. And then we will stand in recess until either one of the attorneys are ready or we find the interpreters logging in. What about Mr. Stevens? Is he there on Mr. Piercefield?
No, sir.
Have we heard from him?
No, sir.
Okay.
Judge.
All right. Court will stand in recess.
Your Honor.
Yes, ma'am.
Mr. Schmidt is ready.
All right, it'll be just a few minutes. Ms. Grisham had stepped out, so it'll be just a few minutes. All right, Mr. Schmidt, who are you ready on? And you're muted, so y'all have to. Is this Cindy Smith?
Yes, sir.
All right, this is cause number CR 21-190, State versus Cindy Marie Smith for docket call. Go ahead, Mr. Schmidt.
Judge, we're ready to proceed with the plea.
Ms. Smith, if you will raise your right hand, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, thank you. Go lower your hand. All right, Ms. Smith, are you a United States citizen who reads, writes, and speaks English?
Yes,
Have you ever been diagnosed with a mental condition?
yes, depression,
Okay. Are you currently on medication or under healthcare treatment for depression? Okay.
yes,
Do you feel like you have a rational understanding today of what's going on?
yes,
And do you feel like your depression is affecting that at all?
no,
Okay. In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and the work that he's done for you as your attorney?
yes,
Do you have any questions about the paperwork that you have read over and signed today? All right. Mr. Schmidt, do you believe Ms. Smith to be competent? And if so, have you explained to her her rights pertaining to this case?
Yes, to both questions.
Okay. Ms. Smith, I see that you are charged by indictment with a state jail felony offense of possession of a controlled substance in penalty group 1 less than 1 gram. I see also that the plea agreement and recommendation in this case is for, upon your plea of guilt, for the court to consider the evidence. And if there is enough evidence to convict you of the offense under section 1244A, which means that you would be convicted as a felon but punished as a misdemeanor. And the DA's recommendation is 233 days in the county jail, with you receiving credit for all 233 days of time served. In addition, you would be ordered to pay a $1,000 fine, $180 restitution, $290 in court costs, and also $585 in reimbursement fees. Ms. Smith, is that your understanding of the plea agreement?
yes,
All right, Ms. Smith, then how do you plead to possession of a controlled substance in penalty group 1 less than 1 gram?
guilty,
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
yes,
And Ms. Smith, has anyone threatened, forced, or pressured you to plead guilty here today?
no,
All right, the court does accept the defendant's plea of guilt. Mr. Schmidt, any objection to the stipulation of evidence?
No objection.
Stipulation is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
No, sir.
All right, court will review the evidence. And upon reviewing the evidence, the court does find sufficient evidence to convict the defendant of this offense. The court follows the plea agreement and recommendation today. Court hereby convicts Cindy Marie Smith of possession of a controlled substance, penalty group 1, less than 1 gram, state jail felony. The court assesses punishment under section 1244A of the Texas Penal Code at 233 days confinement in the Van Zandt County Jail. The court awards Ms. Smith 233 days credit for time already served, orders her to pay a $1,000 fine, restitution of $180, court costs of $290, and reimbursement fees of $585. Ms. Smith, when you are released from custody, you are ordered to pay those fines, court costs, and fees. If you're unable to pay all of those in full at once, then you need to report to the Van Zandt County District Clerk's office in the courthouse and speak with them about making arrangements to pay those off. Your failure to do so could result in you being rearrested on a KPS pro fine or a warrant for not paying fees. Do you understand?
Yes.
All right, so Ms. Smith, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you step over to be fingerprinted. Who's next, Mr. Schmidt?
Brett Turnage.
Mr. Turnage, this is cause numbers CR 24-154, 2024-133, 2024-86, State of Texas versus Brett Lawrence Turnage. Are we doing a plea today, Mr. Schmidt?
Yes.
All right. Mr. Turnage, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today would be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, thank you. You can lower your hand. All right, Mr. Turnage, let me see here. Do you have a question before I start in? So I've got a 1245 for cause number CR 24-154, but I also have a motion to dismiss with the same cause number. And in the plea agreement, it says,
Yeah, I've got 4 copies of the plea paperwork here. What we should have is a 1245 on a terroristic threat.
yeah,
That's
2020.
20, yeah, and then it was gonna, they put a 1245 on the CR 24-154. But that was incorrect. So the motion to dismiss on that case should carry, and we should only be 1245 on the terroristic trial. Does that make sense?
Yes, it does. All right, Mr. Turnage, you are charged by information in cause number 2024-133 with a Class A misdemeanor offense of violation of a bond or protective order. A Class A misdemeanor carries a range of punishment of up to 365 days in the county jail and a possible fine not to exceed $4,000. I see in this case, there is a recommendation upon your plea of guilty that the court convict you of that offense and assess your punishment at 308 days in the county jail, with you receiving credit for 308 days time served. And the state is agreeing to dismiss a filed terroristic threat of a family or household member in cause number 2024-86. And then the state has tendered a motion to dismiss in cause number CR 24-154, in which you were indicted for the offense of injury to a child or elderly individual, a 3rd-degree felony. Is that your understanding, Mr. Turnage, of the plea agreement?
Yes, sir.
All right. So, Mr. Turnage, how do you plead to violation of a bond or protective order?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
And has anybody threatened, forced, or pressured you to plead guilty?
No, sir.
All right, then the court will accept the defendant's plea of guilt. Mr. Schmidt, any objection to the stipulation of evidence?
No objection.
All right, stipulation is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
All right, anything further from the defense?
No, sir.
And Mr. Hartwell, is there victim compliance? Is the victim supportive of the plea since it is a violation of a bond or protective order?
Your Honor, their state is and was in compliance. However, victim has since passed away, which is why we're going this route. This case we could prove at trial, but without a complaining witness, we don't believe we could prove the other cases at trial.
Okay. All right, court's going to review the evidence. All right, court having reviewed the evidence finds that there is enough evidence to convict the defendant of this offense. The court follows the plea agreement on this date. Court hereby convicts Brett Lawrence Turnage of violation of a bond or protective order, a Class A misdemeanor, assesses punishment in accordance with the plea agreement at 308 days in the county jail. Court issues him credit for time served. The court dismisses under section 1245 terroristic threat. In cause number 2024-86, the court dismisses cause number CR 24-154 under the state's motion to dismiss. Further, the court orders Mr. Turnage to pay court costs of $270 and reimbursement fees of $515. Mr. Turnage, when you are released, if you are unable to pay what you owe under this judgment, then you're to report to the Van Zandt County District Clerk's office and make arrangements to get on a payment plan. Otherwise, this court could issue a warrant to have you arrested for your failure to comply with court order. Do you understand?
Sir.
All right. You're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you step over with the bailiff to be fingerprinted. Thanks, sir. Who do you like next, Mr. Schmidt?
Eden Mendez.
And Miss Tabraham, I do have the court interpreters available, so probably after this, we'll go ahead and move them. This is cause number CR 24-239, State of Texas versus, is it Eden or Ed? Eden Joel Delgado Mendez, and we're set for pretrial. Go ahead, Mr. Schmidt.
Judge, we don't have any contested motions need hearing at this point. Ask for a docket call, so.
All right, court sets Mr. Mendez then for docket call on February 18th at 1:30. All right, Mr. Schmidt, if it's okay, I'm gonna bump you out real quick. I've got some interpreters that I'm paying for that I need to get to real quick. With just Mr. Adams and Mr. Wood. Mr. Abraham, is Mr. Adams ready? With Mr. Chen?
We're starting with Mr. Wood.
Okay. All right, let me get my interpreter in here. All right, good afternoon, Ms. Shaw. Can you see and hear me okay? Oh, hang on, I don't think I clicked the English button. I'm sorry, say that again. Okay, I'm not picking you up. Have you, are you in the English channel? All right, so down. Okay, yes, ma'am, I can. I can. Are you good with the simultaneous mode? Okay. Yes, ma'am. Take your time. No problem. Mr. Wood, while we're waiting, Ms. Shaw, how do you pronounce his first name? Is it Win King?
Win. Win con. Yeah. Win con.
Win Kong? All right, will you see if you can establish communication with Mr. Win Kong Lin? And he's already in the Chinese channel. So when you switch over, he should be there. Patty, just make sure you're in the Chinese channel. Make sure you're not on mute, Patty.
听得到. Yeah. Can you hear me?
Excellent. Okay, so Ms. Shaw, at this time, I'm going to ask you to raise your right hand. I'm going to swear you in under your translator oath. Ms. Shaw, if you'll just state your name and your license number for the record. Thank you, Ms. Shaw. Shaw, do you solemnly swear or affirm that you will make a true translation of the statements of the court, the questions of counsel, and the testimony to be given by the witness in the matter now on trial to the best of your skill and judgment, so help you God? All right, thank you. All right, and Ms. Shaw, if at any time the court or Mr. Wood or anyone else that you can't hear us or you need us to repeat, please just speak up, interrupt us so we can make sure that we get Mr. Lynn the statements that he needs, okay? All right. All right, this is cause number CR 24238, State of Texas versus Win Kong Lin. And we are set for pretrial today. Mr. Wood, do you have any announcements on this case?
Judge, right now we're asking for a new pretrial date. I can inform the court kind of what's been going on from my side. I've recently gotten the discovery in the case, and I've had a chance to review most of it. I've not had a chance to go through all of it quite yet, but I've not had a chance to obviously go over it with Mr. Lynn. So my next step is to do that. In addition to that, Your Honor, I do have a meeting set up with Ms. Curry in this case, actually after court today, to start talking to her about progressing this case forward. I do expect that once I go through all the discovery in detail, that I will have some pretrial motions that I'll be filing, that at some point I'll be requesting a hearing upon if we cannot work this out accordingly. But right now, Your Honor, I think a new pretrial date is what I'm asking for.
How much time are you needing, Mr. Wood?
Judge, I think 2 months. Mr. Adams and I are kind of, obviously, he represents the co-defendant in this case. So I think 2 months will give us all time to square the issues away that we need to square away, and hopefully have a more informed announcement at the next pretrial date.
So March 25th, that's about the only time I have in March. And that would be 2 months, a little more than 2 months from today. It's a Tuesday. It's the last Tuesday in March.
Looks like that'll work, Your Honor.
Okay, and just so we can be clear for Mr. Lynn and for the record, when you reference Ms. Curry, you are referencing the criminal district attorney for Van Zandt County, the prosecutor, the chief prosecutor. Is that correct?
That's correct, Your Honor.
Okay.
And I do have a individual who I'm communicating with as part of the Lynn family that does act as an interpreter for me whenever I meet Mr. Lynn. So that is helpful in kind of progressing things forward as well. So we'll continue to do that.
Okay, very well. Any objections or announcements from the state?
No objection, Your Honor. Thank you.
All right, there being no objections, then the court will grant the defendant's request for an additional pretrial setting. Court sets pretrial March 25th at 2 p.m. Court will arrange for a licensed court translator to be present for that hearing as well.
Thank you, Your Honor.
All right, does Mr. Lynn have any questions of Mr. Wood or the court before we conclude his hearing?
No.
All right, thank you, Mr. Lynn. We'll see you back on March 25th. Mr. Adams ready with Mr. Chen?
Yes, sir. It'll be just a second. We've got to get the other defendant.
Okay, I didn't know he wasn't. Yeah, Ms. Shaw, I enjoy using the simultaneous, so I'm sorry. Yeah, anytime that you're in here, we're gonna use the simultaneous. If we're not doing simultaneous, then something's wrong. Something's broken or it's out of whack. And so I believe when your husband was here last, we were having some issues, and so he had to do consecutive. So good, excellent. Mr. Adams, how you doing, sir?
All good.
Feel good?
Yes, sir.
You
How you
feeling
doing?
you feeling froggy? You looking froggy?
Yeah, I'm just ready to rumble.
It's ready to rumble. Well, tonight's not fight night, so unless this is the lead up, maybe a press conference or something.
Yeah, right.
And Ms. Shaw, if you'll go ahead and just establish, this is Wei Zhen Chen.
Legit.
Excellent. Okay, we are on record now in cause number CR 24230, State of Texas versus Wei Zhen Chen. The record will reflect that Miss Ida Shaw has already been sworn in on the record as a master licensed court interpreter to translate today's hearing for Mr. Chen, who speaks Mandarin. And so with that announcement, Mr. Adams, do you have any announcements on pretrial? Is it the same as a joint announcement with Mr. Wood on the co-defendant's case?
Essentially, Your Honor, yes. I do not want to take any actions that could interfere with the resolution of our co-defendant's case, because in doing so, that could be detrimental to our position. In light of that, I'm asking the court to reset us for an additional pretrial date of March 25.
Okay. And I'm assuming no objections from the state?
No objection, Your Honor.
All right, there being no objections, the court resets Mr. Chen's case to March 25th at 2 p.m. And does Mr. Chen have any questions of Mr. Adams or the court before we go any further?
Yeah.
All right, thank you, Mr. Chen. We'll see you back on March 25th. All right, Ms. Shaw, I believe that does conclude our need for your services today. Thank you so much for being here and helping us. Thank you, ma'am. You as well. All right, Mr. Schmidt. I appreciate your indulgence on that. Who are we ready on next?
Reno Marino.
Reno Moreno. Right, Reno Moreno, CR 24242, set for pretrial. Go ahead, Mr. Schmidt.
We don't have any contested pretrial matters at this time. That's for docket.
All right, there being no contested pretrial, court recess Mr. Moreno for February 18th for docket call.
Sure.
That's fine.
Are you ready on Mr. Manning?
Judge, we can start with Mr. Driscoll.
This is cause number CR 24-17, State versus Darian Christopher Driscoll. Is Mr. Driscoll going to be a plea today?
Yes, Judge.
All right, Mr. Driscoll, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today would be the truth, the whole truth, and nothing but the truth, so help you God?
Sir.
All right, thank you. You can lower your hand. Is your name Darian Christopher Driscoll?
Yes, sir.
And Mr. Driscoll, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning and the work that he's done as your attorney?
Yes, sir.
Do you have any questions about any of the paperwork that you have read and signed today?
No, sir.
All right, Mr. Manning, do you believe your client to be competent? And if so, have you explained to him his rights as they pertain to this case?
Yes, Judge, I have.
All right, Mr. Driscoll, I see here that you are charged by indictment with a second-degree felony offense of possession of a controlled substance, penalty group 2, in an amount of between 4 grams and 400 grams. A second-degree felony does carry a range of punishment of not less than 2 years or more than 20 years confinement in the Texas Department of Criminal Justice, and also a possible fine not to exceed $10,000. I see that you were also in your indictment, you were alleged to have had prior enhancement paragraphs to which it appears that in the plea today, the state is recommending that upon your plea of true to the first paragraph, that they would abandon their second allegation enhancement paragraph upon your agreeing to what appears to be 10 years confinement in the Texas Department of Criminal Justice, plus restitution of $180, court costs of $290, reimbursement fees of $95. And towards that 10-year sentence, you would receive your total jail time credit of 504 days. Is that your understanding, Mr. Driscoll? Okay. All right. Understanding all of that, Mr. Driscoll, how do you plead to the second-degree felony offense of possession of a controlled substance, penalty group 2, greater than 4 grams, less than 400 grams?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
And has anyone threatened you, forced you, or pressured you to plead guilty?
No, sir.
Court does accept the defendant's plea of guilt at this time. Mr. Manning, any objection to this stipulation of evidence?
No objection to stipulation, Judge. One thing I would like to point out is, for record purposes, Mr. Driscoll's name is spelled correctly on the judgment and is correct in all paperwork here. However, there was some issue with his TDC bookend information, and it spells his last name Driscall. I've assured Mr. Driscoll that this number will follow him down. He will be receiving credit for time that was spent on this case, whether it was under that name or under his correct name.
So you're saying that in Van Zandt County, his name is correct, but at some previous time in the past, TDCJ entered his name incorrectly.
That is correct, Judge.
And that in the state here in Van Zandt County has prosecuted him under his proper name, not an alias that TDC could have created by data entry.
That's correct, Judge.
Okay, very well. Thank you for noting that. All right, then the court does admit the stipulation of evidence and does take judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Mr. Manning, anything further?
Rest in peace, Judge.
All right, court will review the evidence. I'm not seeing that I have a stipulation here. Is there any way you could just display that on the screen, Mr. Manning?
Yes, Judge.
And let me double check. Maybe I went over it, but yeah, I don't have it. Just a little closer. There you go, right there. All right, thank you, Mr. All right, so Mr. Driscoll, I do need to ask you at this time, how do you plead to the enhancement paragraph alleged in the indictment, the first enhancement paragraph? Is that allegation true or not true?
True.
All right, has anybody threatened or forced or pressured you to plead true to that enhancement paragraph?
No, sir.
All right, so Mr. Manning, just so I'm clear, this enhancement paragraph is not enhancing the sentence any more than what is the typical range. It's a 10-year on a second degree, but it's not being enhanced to, or is it going to say first? It should say first degree if we're going to plead true to first. So the judgment where it says second degree should say first degree. Is that correct?
That is correct, Judge.
Okay. So Mr. Hartwell, we'll need the front page of the judgment changed from second degree to first degree.
Yes, sir.
All right, so Mr. Driscoll, the court, having considered the evidence and accepting your plea of guilt, the court finding that the enhancement paragraph, the first enhancement paragraph to be true, court finds that the second enhancement paragraph has been abandoned by the state. Court, considering the evidence, hereby finds that there is enough evidence to convict you of this offense. The court will follow the plea agreement and the recommendation. Court hereby convicts you of the first degree felony offense of possession of a controlled substance of penalty group 2, greater than 4 grams, less than 400 grams. Assesses your punishment at 10 years confinement in the Texas Department of Criminal Justice Institutional Division. The court does find the first enhancement paragraph to be true, finds that the second is abandoned. The court also assesses restitution in the amount of $180 and court costs in the amount of $290, reimbursement fees in the amount of $95, and the court awards you, Mr. Driscoll, 504 days credit towards your sentence for the time that you have spent in jail on this cause. All right, Mr. Driscoll, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you step over to be fingerprinted. Good luck to you, sir.
Judge, next, before we begin on Mr. Daniel's case, there are a couple things I think we might need to clean up. One is on CR 2447. That plea is going to be to a misdemeanor. It's going to 1245, another case, unfiled case. But on the reimbursement, there was put on there reimbursement for attorney's fees. Mr. Daniels retained my services to represent him in all these cases. So we'll need to get a corrected judgment and court cost sheet reflecting that change of him not needing to pay court-appointed attorney's fees.
All right, so let's see. I don't see any attorney fees on the court costs, on the bill of costs.
On CR 2447, if you like, I could provide a copy of that.
I think the only one I've got is 2024-57. I think I have any other bill of costs. Maybe I do. So is he also pleading to 57?
Yes, Judge, and that brings the second issue. In looking at that case from the county court at law, I believe that was transferred up in December. But once again, I don't have record of that as of this morning, right at my fingertips. I've contacted the court coordinator for the county court at law, but have not heard back or received documentation that was transferred. So
I can look in that real quick.
It was, Your Honor.
it was done on August the 5th, 2024.
All right, so we need the front page of that to be changed to the 294th District Court.
That's correct, Judge.
All right, so in cause number CR 2447, we need the front page to be redacted to reduce the attorney fees that were assessed in the bill of cost at $500. So the reimbursement fees should be $35.
And Judge, that'll also be on the second page right above your signature line and the special findings.
All right, and then cause number 2024-57, just the style to say in the 294th District Court.
That's correct, Judge.
And let's see, yeah, there were no court costs assessed there. Jail time credit is $365 in both cases.
Yes, Judge.
Okay. All right, Mr. Hartwell, do you have those noted?
Yes, sir.
Okay. All right, we'll go ahead and go forward. All right, Mr. Daniels, sir, you will raise your right hand. I'm going to place you under oath. Mr. Daniels, do you swear that the testimony you give to the court today would be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thank you. You can lower your hand. All right, your name is Robert Morrell Daniels II, is that correct?
Yes.
And Mr. Daniels, are you a United States citizen who
Yes.
reads, writes, and speaks English?
Yes.
And have you ever been diagnosed with any type of mental condition? No? And in this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning and the work he's done for you?
Yes, sir.
Do you have any questions about the paperwork that you've read over and signed today?
Yes, sir.
Mr. Manning, do you believe your client to be competent? And if so, you've explained to him his rights as they pertain to each case?
Judge, he is competent. He has been able to assist in his defense. I have explained his rights and the waiver therein, and he has intentionally, knowingly, and voluntarily waived his rights.
All right, thank you. All right, so Mr. Daniels, in cause number CR 24-47, you were charged by indictment. Is that correct, Mr. Manning? Charged by indictment?
Judge, yes, it was originally charged, I believe it was assault public servant by indictment, and they are reducing that to the Class A, resisting arrest or transport.
Okay, and so Mr. Hartwell, maybe on CR 2447, we should, in the terms of the plea agreement, say pleading guilty to lesser included offense of resisting arrest, search or transport.
Yes,
All right, so Mr. Daniels, in that case where you were originally indicted with assault of a public servant, I see that the plea agreement would be you pleading guilty to a lesser included offense of resisting arrest, search or transport, a class A misdemeanor, which does carry a range of punishment up to a maximum 365 days in the county jail and a possible fine not to exceed $4,000. The plea agreement appears to be upon your plea of guilt, the DA's office is recommending that the court convict you of that offense, assess your punishment at 1 year confinement in the county jail. You would receive credit for 1 year of time already served. In addition, you would have a $500 fine, $270 court cost, $35 in reimbursement fees. And the DA's office is agreeing to dismiss another resisting arrest, search or transport in their unfiled case, DA 2024-69. In your other case, which is case number 2024-57, in which you were charged with evading arrest or detention by information, a class A misdemeanor, which carries the same range of punishment up to a maximum of 365 days in jail and up to a $4,000 fine. The plea offer and agreement appears to be the same. Punishment to be assessed upon guilty at 1 year confinement in the county jail with credit for time served. In that case, you would be responsible for court costs of $270 and reimbursement fees for $15. Is that your understanding of the plea agreement in each case, Mr. Daniels?
Yes, sir.
All right, then at this time, I would ask you, how do you plead to resisting arrest, search, or transport a lesser included offense of assault of a public servant?
Yeah.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes.
And Mr. Daniels, has anybody threatened, forced, or pressured you to plead guilty to that crime?
No.
Mr. Daniels, how do you plead to evading arrest or detention?
Guilty.
Are you pleading guilty to that crime because you are guilty of that crime as well?
Yes.
And has anyone threatened, forced, or pressured you to plead guilty to that crime?
No.
All right, then the court will accept the defendant's plea of guilt in each case respectively. Mr. Manning, any objection to the stipulations of evidence?
No objection as offered.
Stipulations are admitted in each case respectively, and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, only that the officers involved are supportive of the plea.
Thank you, Mr. Hartwell. I do appreciate that. Anything further from the defense?
Rest in close, Judge.
All right, court will review the evidence. Mr. Manning, I do not have a stipulation of evidence.
Yes, Judge.
You assist me, please, sir. I'm assuming it's gonna be the same fact pattern for each case.
That's correct, Judge.
A little closer. Okay, back up just a little bit for focus. Perfect, right there. Thank you. Appreciate that, Mr. Manning. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant of this offense. The court follows the plea agreement. In each case, court hereby convicts Robert Morrell Daniels II of resisting arrest, search, or transport and evading arrest, detention, both Class A misdemeanors. The court assesses punishment at 1 year confinement in the county jail in each case, issues him credit for time served, orders him to pay a fine of $500 in cause number CR 2447, court costs of $270, reimbursement fees of $35, and the court dismisses another unfiled resisting arrest or search or transport in DA 2024-69. Court also assesses court costs of $270 and reimbursement fees of $15 in cause number 2024-57. All right, Mr. Daniels, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you step over to be fingerprinted. When you do get out of jail, if you can't pay your fines, court costs and fees, you'll need to report to the courthouse and speak with the district clerk on the third floor and make a payment arrangement, okay?
And Your Honor, I've explained that process. However, Mr. Daniels will remain in custody after this. And so I've explained to him that once he does get out of wherever he gets to next, he will need to check in with the clerk's office to make those payments.
Thank you, Mr. Manning. All right, who would you like next?
Judge, we can start with. Let's start with Mr. James Dennis.
James Dwayne Dennis, cause numbers CR 23-10, CR 24-96, CR 24-130, CR 24-131. I show that they're all set for pretrial. Go ahead, Mr. Manning.
Yes, Judge. Mr. Dennis just arrived here. And I received some information from him that I'd like to present to the DA's office to resolve his case. If we could short set him to Thursday, we may be able to get a resolution on his case.
Okay, any objection from the state?
No objection, Your Honor. Thank you.
All right, court will set Mr. Dennis then for this Thursday, January 23rd. You want that for, what do you want that set for?
Judge, if we want to go ahead and set it for
Docket call or?
docket call, that'd be fine.
All right, docket call in each case 123 at 1:30. Who do you want next, Mr. Meany?
Judge, next, if we can have, hold on just a second. If we can have, sorry, Judge. Sorry. If we can have Mr. Justin Guyton.
Justin Dramel Guyton, CR 24-54 for pretrial. Go ahead, Mr. Manning.
Yes, Judge. No contested pretrial at this time. A request to be set on the docket call announcement. And if we could set that on the February 13th date.
All right, court sets Mr. Guyton then for docket call February 13th at 1:30.
Next, to have Mr. Dennis Jones.
Dennis Ray Jones, CR 24-167, CR 24-274. Show that we're set for arraignment on the new charge of evading arrest or detention with a vehicle. Let's proceed on that one first.
Judge, if you wouldn't mind pulling up a copy of the indictment.
Can you see that, Mr. Manning? Does it need to be larger or smaller?
Judge, that's good. If you could just scroll down just a little bit. Judge, at this time, we have had a chance to review the indictment in this case. My client's name is spelled correctly. He understands the charge against him as well as the range of punishment and pleads not guilty and requests to be set on the pretrial docket.
All right, then the court enters Mr. Jones' plea of not guilty into the record, finds that he's waived the formal requirements of arraignment. Court sets Mr. Jones for pretrial, and I'll carry the docket call with it in the other case. Mr. Manning to is February 13th enough time?
Yes, Judge.
All right, we'll set pretrial February 13th. We'll carry the docket call along with it.
Thank you, Judge. And Judge, I'll also need the indictment on Miss Miller, Station Miller.
If she's in there, go ahead and bring her up.
Miller. Yeah, if you want. Are you all right to work? Okay.
Judge? Can you hear me?
Judge, Miss Miller's name is spelled correctly. She understands the charge against her as well as the range of punishment. Her plea is not guilty and she requests to be set on the pretrial docket.
Right, the court finds that Ms. Miller, having waived the formal requirements of arraignment, enters her plea of not guilty into the record. We set this matter then for pretrial hearing on February 13th at 9 a.m. I'm sorry, at 1:30.
And Judge, if we are able to reach a resolution prior to that, would the court entertain Miss Miller's case being heard earlier?
Yes, sir. So it looks like I've got Thursday, and then the next 2 days would be the 11th and the 13th. So the earliest I could get her in would be Thursday of this week or the Tuesday prior to that 13th date.
Yes, Judge. This is just saying what's the date.
Who's next, Mr. Manning?
Oh, he's coming later. Okay,
He's in the cell.
that's fine. That's fine. We can get Mr. Teddy Robinson. We'll also need indictment on him as well.
All right, Teddy Maurice Robinson, CR 24285.
So I don't know what the order got me.
Is your name spelled correctly? Teddy Louise Robbins. Is that correct? Yes. And so they're saying on or about September 7th, 2024. Additionally, they're trying to raise that party. So, Judge, Mr. Robinson's name is spelled correctly. He understands the charge against him as well as the range of punishment. He asked to be set on the pretrial docket so we can get discovery and go over that as well as prepare for our defense.
All right, court enters Mr. Robinson's plea of not guilty into the record, finds that he's waived the formal requirements of arraignment. Court sets Mr. Robinson's matter for hearing for pretrial on, is the 13th enough time for you, Mr. Manning?
Yes, Judge.
All right, court sets Mr. Robinson for pretrial on February 13th at 1:30.
Thank you, Judge.
Who'd you like next?
Judge, the only one I have left is Mr. Slow.
Yeah, I've got some information on that. This is cause number CR 24-149. State versus Christopher Paul Slew. And Mr. Slew is in TDC. And he's in the Beto unit. He's got a projected release date of February 21st of 2031. It looks like Mr. Slew was sentenced in Dallas County in October of last year. He caught a 7-year sentence for assault, impeding breath circulation, aggravated assault, deadly weapon, 7 years on each one of those, and also failure to comply with sex offender duty to register for 10 years, and he received a 5-year sentence on that. So I guess state, I'll just need to know if you want us to bench warrant him back for this offense or how you want to proceed.
Your Honor, I think given the nature of our charge, we would like to go ahead and proceed. I imagine we'd be able to come to an arrangement where we're able to work it out pretty quickly, though.
All right, court will set Mr. Slew then for, I'm going to say for March 27th, Mr. Manning, since he's in TDC. And that'll give us time to get a bench warrant. And that's the earliest I have. We got spring break that week. I got a 2-week trial, beginning of March, spring break, and then a criminal trial, and then one setting for Tuesday and Thursday. So we'll set him March 25th for arraignment.
Yes, Judge.
And then, Your Honor, I see Mr. Parker is on the docket. Stated filed a motion basically requesting leave to release some grand jury testimony to defense. I haven't checked today or in the last couple of days, but I didn't know if the court had received that motion or had a chance to sign it.
Yeah, I did review it. I think I had some initial questions, but is there any objection by the defense?
No, Judge. I haven't looked at the motion, honestly, but we are requesting there was a key material witness that testified at the request of the defense before the grand jury. And so we would request, obviously there's mitigating exculpatory evidence that was procured. We'd ask that be released to us.
I think the initial question that I had, Mr. Hartwell, is because this is not a typical motion, I went and reviewed the statute, and I was concerned a little bit, because the code is clear on when the grand jury, transcripts can be released. And there's really not a mechanism for the DA's office to release them, more so than it is for a defendant to request for them to be released. Is your request based on, you believe that there is mitigating or exculpatory information in the grand jury testimony transcripts that you believe 3914 requires you to produce to Mr. Manning?
Your Honor, I don't believe there's anything that Mr. Manning is unaware of as far as mitigating or exculpatory. I haven't, I know there was testimony. I was not actually present for that, so I haven't gone through in detail myself. And I'm sorry, it looks like Mr. Hernandez may have some to add.
Yes, Your Honor. Really, this, I think the invitation was extended to a witness, at least a witness that the state intended on calling. The defense made us aware that they had received a letter written by this witness, which was certainly at odds with the information we had in the case in chief, or at least in the police reports generated. Obviously, we needed to know which side of the story was what the witness ultimately would be testifying to. And it's for that reason that he was summoned before the grand jury to obtain that information. It's obviously information I believe that the defense should have, because we still fully intend on contacting that witness and introducing his testimony in trial, should the case proceed to trial.
Yeah, I guess my question though is, and I want to make sure that this court can authorize the release of it under those grounds. So reading the motion, it indicates that, so Mr. Jenkins, Isaac Jenkins, who's a co-defendant in this case, pled guilty back in September. And it says subsequent to him pleading guilty and being placed on probation. And here's the letter you're referencing, that Mr. Jenkins sent a letter to, I'm presuming, Mr. Manning?
Yes.
Yes.
Counsel for Mr. Parker, indicating that Mr. Parker was not involved in the burglary. So Mr. Manning has received the letter from Mr. Jenkins indicating exculpatory mitigating evidence. However, what you're indicating is that Mr. Jenkins had testified during the grand jury and implicated Mr. Parker, and that I think you referenced that there was videos to support that testimony, or that the video identified them, and that Mr. Jenkins positively identified Mr. Parker in that video as being Mr. Parker. Is that correct?
That's correct, Your Honor.
So I guess my concern is this: what is mitigating or exculpatory about what he told the officers? Because Mr. Jenkins implicates Mr. Parker. Where he doesn't implicate, or where he mitigates or exculpates Mr. Parker, is in a handwritten letter, or a letter that he tendered to Mr. Manning. So as far as Mr. Manning being aware of mitigating or exculpatory information, he's got that. He's got that evidence. What you have in the grand jury transcripts appears to be incriminating evidence.
It isn't. I'm sorry. It is incriminating, Your Honor. It's actually confirmation of the initial police reports that were generated in this investigation.
Right. So I'm saying you don't have to turn a grand jury transcript over to incriminating. You'd only have to turn it over if it exculpated him, or was exculpatory, or it was mitigating.
And Judge, just one thing to help clarify, this grand jury testimony was done after the case was already indicted and after I received a letter. And so I believe that while the state, I don't know what the transcript says, because I don't have a copy of it. And so when I asked specifically what was testified to, I was told that we would have to take this route to have the transcript released. I was informed.
Yeah, and council remind me, I was reviewing this the other day, but I can't remember what chapter. I think this is gonna be somewhere around 19 in the Code of Criminal Procedure. I want to read over some of this with the both of you and tell me if I'm reading this incorrectly. So I'm looking at 20A.204. Disclosure by attorney representing state. Says the attorney representing the state may not disclose anything transpiring before the grand jury except as permitted by this specific article or 20A.205A or B. We're going to read that in a minute because that pertains to a request from a defendant. So as it says, in performing the attorney's duties, the attorney representing the state may disclose or permit a disclosure of a record made under 20A.201, which says that's a recording of accused or suspected person's testimony. And it says, or a typewritten transcription of that record, or make or permit a disclosure otherwise prohibited by the article to a grand juror serving on a grand jury, another grand jury, a law enforcement agency, or a prosecuting attorney, as the attorney representing the state determines is necessary to assist the attorney in performance of the attorney's duties. And then sub C says the attorney representing the state, shall warn any person about the confidentiality of it. And then D is any person who receives it, can be punished for contempt. So there's nothing in there that says has to do with mitigating or exculpatory. And then so we look at, okay, if Mr. Manning would have made this request on behalf of Mr. Parker, then it says the defendant in 20A.205 sub A that the defendant may petition a court to order disclosure of the transcripts or any other record as a matter preliminary to or in connection with a judicial proceeding. The court may order disclosure of the information if the defendant shows a particularized need. And then sub B says a petition for disclosure under A must be filed in the district court. Defendant must also file a copy with the attorney representing the state, the parties to the proceeding, and any other person the court requires. And each person who receives a copy is entitled to appear before the court. And then court shall provide interested parties with an opportunity to appear and present arguments for or against the requested disclosure. So those are the only two statutes that I'm aware that the court could grant the releasing of a record that is deemed secret and confidential pursuant to the grand jury statutes. So I don't see anything under 204 that allows me to release this on the state's motion. Now, go back to our first conversation about, okay, is this 3914? I don't see this to be 3914 because he incriminated. If anything, it's impeachment evidence.
Well, and Judge, I'll be honest, I was going under the assumption when I was told that we need to request that it was mitigating exculpatory. I didn't know what evidence was or what testimony was given at the grand jury. I just assumed that it would be helpful for my client, which is why I assumed the state filed their motion.
Well, I mean, it may be helpful, but not in the terms of mitigation and exculpatory. It may be in terms of impeaching
Yes,
the
Judge.
person who implicated your client.
Let's do this. If we want, we can just go ahead and set this for jury selection, and then I will file a motion to get that from the defense for those purposes.
Okay, and before we do that, so I looked through 3914, And so 3914 sub H says, notwithstanding any other provision of this article, the state shall disclose to the defendant any exculpatory impeachment or mitigating document, item, or information in the possession, custody, or control of the state that tends to negate the guilt of the defendant. So I tried to read it in the way that would try to honor y'all's agreement to make sure that the court could disclose it. And unfortunately, I think under H, under impeachment, that would be, I don't know that what they have, that I don't think that that grand jury transcript is impeachment evidence. Now you have the letter, that says he didn't do it. So the one that would be wanting to impeach him would be the state. It wouldn't be the defense. And 3914 is for the defense. It's for the state to disclose to the defense impeachment evidence. And so I viewed this in a way that you would not be trying to impeach. I don't believe, Mr.
Jenkins.
Correct. So I could be wrong on that. That was my initial read of it and I wasn't sure. But if you want to file that, Mr. Manning, and then I can, we can set it for a hearing. And if there's no objection by the state, then I think that I've done my job in making sure that the statute's been met. I wouldn't have any problem releasing it under a petition from the defendant wherein the state agrees.
Yes, Judge.
And Your Honor, I'm sorry, Mr. Manning. That's really where we're coming from, Your Honor, because we believe that it's important enough for the defense to be aware of the information that was shared by Mr. Jenkins. Really, this was more of a reaching out to the authority, Your Honor, for permission to disclose that. We would certainly have no objection if Mr. Manning were to file a motion requesting that. And just so we're all on the same page, it is not a written transcript. It would be an audio file.
And so what I would propose, if you just want to submit an agreed motion or agreed order, you can do an agreed order, lay out all of those things that I have to do under 28, Mr. Manning. Do you have that statute? Do you want me to give that to you again?
No, Judge, I haven't. Thank you.
Okay. If you'll lay that out in agreed order and state and defense sign that, then I'm good.
Yes, Judge.
So not trying to make it more difficult for you, but just trying to make sure we don't set a precedent.
Absolutely, Judge.
A poor precedent, I should say. I'm all about setting precedents. Only good ones, hopefully.
And Judge, I just want to make sure that we're clear. I know Mr. Manning said something about setting for jury. Part of the reason why we want to make sure that all the information is out there is for negotiations. But if we're going to set for jury today, we're going to go to trial. We're not going to engage in any further negotiation.
What do you want to do on that, Mr. Manning? Do you want me to set it for another docket call so you can get the audio file, evaluate it, and determine if there's any negotiation? Or can you say today it doesn't matter what's on it?
Judge, in light of this, I can speak to my client, but I'm 99% sure that his answer is going to be set it for trial and set it for as soon as possible. So if I may just have a moment.
Yes, sir, please. All right, Mr. Randy, you ready, Mr. Parker?
Yes, Judge.
All right, let me go ahead and, I don't think I've officially called this case. This is cause number CR 24-184, State of Texas versus Kevin Winfred Parker. Go ahead.
Judge, after speaking to Mr. Parker, we are concerned as to what was actually said on the grand jury, just because it does not line up with the letter and other communications that I have received from the witness. And so we would request to have that set for docket call on the February 13th docket.
Okay.
And that, Judge, if we need to, that could be a final docket call as well.
Okay. All right, court will set Mr. Parker for docket call February 13th at 1:30.
And Your Honor, just so we're all on the same page, I'm anticipating Mr. Manny then will be tendering that order to us for signature and then to the court for release.
That's my understanding, correct, Mr. Manning?
Yes, Judge.
All right, yeah, so you don't have to file a motion. If you just want to submit an agreed order, circulate it for signatures, submit that. I'll get it signed. That way they can go ahead and get on that and get that to you prior to the 13th.
I'll have it done today, Judge.
All right, thank you, sir. All right, let's see. Do you have anyone else?
Judge, I believe that concludes my business. May I be excused?
You better ask my boss. Check in with my boss. If she says it's good, then you're good.
Yes.
He says, yes, sir.
All right, you better listen to the woman.
Thank you, Judge.
All right, so we got Mr. Piercefield.
Yes, Your Honor.
Come on up, Mr. Piercefield. This is
I just sent you a text if you'll look at it.
Yes.
I haven't told Mr. Piercefield, but
Okay, so Mr. Piercefield, Mr. Stevens is not here today, and it's not due to his mistake or unavailability. We reset all of these cases from January 9th. That's when we had the ice storm, and we did not notify Mr. Stevens that we were resetting for today. So let's reset you to Thursday. We'll get a hold of Mr. Stevens and try to get you handled on Thursday. Okay? Have you met with Mr. Stevens since the last time he was in court? He didn't come by and see you? Okay. All right. We'll talk about that on Thursday. Okay. So let's reset him to January 23rd at 1:30, and we'll notify Mr. Stevens today.
Thank you, Your Honor.
You're welcome.
it's my oversight. I'm sorry. Started. Thank you.
All right, Patty, is that everybody on the jail docket?
Yes, Your Honor.
All right. All right, appreciate your help. Y'all did a good job today on 97 cases. We did pretty
I
good.
know. Amazing.
Well, when you got a good team all the way around,
Oh, well,
from
thank you.
defense to state, it works out well. So, all right, thank you, gentlemen. Appreciate it. That'll conclude our docket today, and we are adjourned.
Thank you, sir.
Thank you, sir, very much. Bye-bye.
You're welcome.